Okay, can you guys hear me? I think I got my sound open.
Yes,
You
we can
guys
hear
would
you.
just put something in the chat to let me know you guys can hear me okay. Okay, awesome. Thanks, Alyssa. And then also I'm screen sharing. If I keep the chat open, just in case questions come up, can you guys see the chat from my screen, or is that something you don't, I don't think you should, I don't think you can see my chat box. Like in a different window, Alyssa? So you can see the chat right now? You can't see the chat. Okay, good. Then I'll leave it open. That way, if anybody has questions, I won't miss them. I just don't want to muddy the screen if it is. So we're just gonna wait a couple more minutes to get started. So do whatever you need to do in the next few minutes, and we're gonna try to start right on time because we have a lot to cover today. I'm very excited about this. Okay, I think we are going to get started. People are starting to pop in, and we had a huge response to this. I think we had like 88 RSVPs, which is really exciting. So I'm not sure everyone will join live, but we are recording this. So hopefully Chief will share the recording, but if not, I think I can save the recording on my computer and share it I'll share a link to it in our discussion for the RSVP for this group on Chief, so you guys can access the recording. But I'm not going to come on camera this time because we just got so much to cover. I didn't want to spend time messing with the tech and eat up valuable time for that today because we do have a lot to cover. But I would absolutely love to know where everybody is watching from. So if you want to introduce yourselves in the chat, feel free to share your LinkedIn link if you want, so people can connect with each other. That would be awesome. I would absolutely love to see who's here today as we get started. And I am watching the chat, so I won't probably be able to answer every question as they come through. But if I see one that seems relevant to what we're discussing, I'll get to it. And then if we have time at the end, I will try to address whatever questions we have not addressed yet. So my recommendation would be unless you have a question about something that I'm talking about at the moment, leave it to the end so I don't miss it, because it'll be hard to scroll all the way back to find it later. So hi Chantel, Lake Tahoe, nice. Oh, that sounds beautiful. I'd love to be there right now too. That sounds really great. So I hope everybody else will share where they are, share their LinkedIn And in the meantime, I will get started. So my name is Jessica Eves Matthews. I'm a very proud member of Chief. I absolutely love this organization. I've only been a member since the beginning of the year this year, but it's just been absolutely phenomenal. I've met some amazing women. Oh, we got Clarkston. Is that Missouri or is that Michigan? I should know. Am I? Anyways, Andrea, welcome. But I have been a lawyer for, 27 years now. And just to give you a little bit of my background, I have represented businesses of all sizes, from startups and small businesses all the way up to Fortune 1000, Fortune 500 companies. I've represented Coca-Cola, DirecTV, DreamWorks. I've represented several of the most successful billionaire entrepreneurs in the world. Oh my gosh, we have someone from Scotland. Hi, is it Ella or Isa? I wonder if that's how you say your name, but okay, great. Welcome. I love that you're here from Scotland. That is a place that I really want to visit. So I'm excited to have you in here. And I'll make sure I save the chat at the end, and everybody do that as well, so we can all connect with each other, both on Chief and on LinkedIn. But so I'm just giving, some of my background. I've really represented every type of business, and I've been there in every phase of the business life cycle. And, much of what I have done for these clients is, oh my gosh, we've got someone from Maine who's on the path of the Hurricane Tropical Storm Lee. Robin, I hope that you stay safe. And hi, Michelle from LA. I won't give everyone a shout out as you guys come in here, but before I jump into the content, I thought I would acknowledge you guys, especially the hurricane. I hope that you stay safe. But what we're going to talk about today, these are the things that I do for my clients. So I'm either helping them protect, purchase, defend, go after, or in some ways monetize or leverage the intellectual property assets we're going to talk about today. And no matter where you are in your business, no matter what your role is in your business, these lessons that I'm going to be talking about today apply. And you're going to be if you're not the owner of your business, if you're an executive, having an understanding of this is going to be of huge value to your organization. And then also, if you are a founder, this is vital information for you. So let's jump in. First, before I start, I need to say, obviously, that I'm not intending legal advice. I'm a lawyer, so I got to give the disclaimers. I'm not making a guarantee of any kind of specific results. Legal matters are very fact-driven. You definitely need to consult with a lawyer about your specific situation to get good advice. And so obviously no attorney-client relationship is created by you attending this webinar, accessing my website, or anything like that, but I would love to assist you. So if it turns out what I have to say is useful and you decide you do want to reach out to me, I will give you the ability to do that at the end of this. And it would give me great pleasure. It would be a real honor to assist you in protecting your business and your company's intellectual property. But this is for educational purposes only today. So it's really important that you understand that intellectual property can make or break your business. I have seen companies succeed and fail solely based on how they handle their intellectual property. And oh my gosh, we've got some fabulous locations represented, New York and London. Anyways, no matter where you are in your business, like I said, the lessons I'm going to teach are going to be the same. And this is going to really bode well for your future in your business if you take this advice today. So let's go over the 4 types of intellectual property that we're going to be discussing today. What's going to need protection in your business, or what do you already have potentially that may be at risk, and that you need to protect. The first one is trademarks. Trademarks are very near and dear to my heart. I do a lot of trademark work for clients, and trademarks are absolutely vital to your business. And the more successful you get, the more important they become. Copyrights also are a really important part of business. So we're going to talk about these in a little bit more detail, but trademarks basically protect the brand, the branding, anything that is a source identifier for the business would be protected by trademark. So of course, your brand name, product name, logos. We'll talk about, some other types of things that can be trademarked. Copyrights protect original works of authorship, and authorship can include anything from, music to art to architectural drawings to maps. So it's not just an artist or an author. Copyrights protect a lot of different things, but it's as soon as the item is put into a fixed form, it becomes automatically protected. And again, we'll talk about that in a little bit more detail. Patents protect new inventions or innovative methods. It can also protect designs. And basically, a patent is a government granted monopoly to build, sell, or use your invention, and prevent others from doing that for a certain period of time. And if you're issued a patent, there's different types, and we'll talk about them and how long they last. But the longest patent is going to last 20 years. And so we are going to talk about how important it is to layer the different types of intellectual property to give you, more holistic protection and also longer term protection. So patents can be very useful. Not everybody needs a patent. I would venture to guess that almost every business needs trademarks. Probably every business needs copyrights. Some businesses will need patents. And then the last type of intellectual property that we're going to talk about today are trade secrets. And every business absolutely has trade secrets. Trade secrets are basically intellectual property rights on confidential information that may be sold or licensed. And generally, to qualify as a trade secret, the information needs to be commercially valuable because it is a secret. So it's the secrecy that is a really important part of it. And it can only be known to a limited group of persons. So think of it like a secret recipe. I think of like Coca-Cola's original Coke recipe is absolutely a trade secret. Pepsi would love to get their hands on that information, and that's what makes it valuable. And so it has to be something that people can't, it's not readily available, it's not publicly available. And so, anything from chemical formulas, product designs, even consumer or customer lists, pricing schedules, manufacturing techniques, and then also even marketing strategies. So if you've got sort of a 5-year plan or a 2-year plan or something that you're launching, these types of things would be considered trade secrets. And we are talking specifically about, and Dara, that's a great question. Let me address that in just one second. Let me just say generally that what we're going to be talking about today is specific to US law. And so every country has their own trademark registry, their own copyright registry, their own patent registry, and their own body of law that governs all of those things and trade secrets. And so, we're only talking specifically about US law today, but be aware that it's very possible if you do business or if you manufacture goods in other countries that you're actually going to need these things, not just in the US, but in more than one country, in the countries that you're doing business in. And so it's important to be aware of that. And I have clients all over the world. And so, this is something that I deal with every day in my practice. Now, Dara asked where a service mark fits in, and that is a great question. Trademarks are really, there's several different types of trademarks, but a service mark is a type of trademark. So if you sell products, generally your trademark is called a trademark. So that's how it's going to be referred to. If you sell services, your trademark will be referred to as a service mark, but it is just a source identifier. It's not any different than a trademark. You don't make that distinction on trademark applications with the USPTO. They will make the distinction when they issue your registration. They will tell you whether you have a service mark or a trademark, but it's basically the same thing. So it is your brand name. If you have names for like specific services that you offer, those could be trademarked, your logo, taglines, all of those things. Anything that a product-based company could have, a service-based company can have, and those marks are just going to be referred to as service marks. So that is a great question. So let me just tell you really quick before we get into the specifics of each type, what our agenda is going to be for this discussion. So we've already talked about the types of intellectual property. We're first going to jump into trademarks. So we're going to talk about how you would choose a strong brand, what makes a brand a strong one, how you protect it, what those steps involve. And then we're going to jump to copyrights and then patents. And lastly, we're going to talk about how to keep your trade secrets confidential. And then we're going to bring it home with a discussion about how to make sure your IP is protected across your entire business. And that is an area that I find is most of the people that I work with and meet in the business world have the greatest need in that space. And so we'll talk about it when we get there. I think that's probably one of the most important things we're going to talk about today. But let's jump into trademarks. And we've only got an hour, so I'm going to fly through this information, but we are recording it. So hopefully if you need to go back and review, you can, and I'm always available if you want to reach out to me for questions. But trademarks, as I mentioned, are source identifiers. They are going to identify you as the source of the goods or services that you sell. And a strong brand is one that your business is going to own exclusively, and this is in your industry. Basically, the way trademarks are determined have to do with the specific goods and services that you sell. Now, some businesses do sell both products and services, and so your mark, the scope of your trademark is going to be determined by that, and so your trademark will not be broader than within the category of the goods or services that you actually sell. It might also encompass categories that would be considered related to your business if they are sort of like a logical extension or a coordinated type category. So it might be foreseeable that you would branch into that. You might get protection in that, even if it's not covered by your registered trademark. But we're talking, specifically about, we are talking specifically about sorry, I got distracted because I realized that I wasn't hearing anything. And if everybody could just make sure you mute so that you're not distracting everybody, that would be great. I think I had my computer on mute, so I didn't actually hear if there was noise. So I've fixed that. And hopefully you guys can hear me well. But so the goal is to own your trademarks exclusively. And the way to do that is you're going to want to market as memorable and unique. It needs to be as unusual and memorable as it possibly can be. And a strong brand is going to be something that you can monetize, leverage for growth, and potentially even for an exit if that is your objective. Also, if you have a plan of having investors in your business, they are absolutely going to want to see that you have secured your intellectual property, including your trademarks. And so a strong brand is one that you're going to be able to get a registration in because not having registration could prevent you from getting investment. There's an echo when I speak. Is that what you're saying, Nita? Was that there before, or when I unmuted myself, is that when that started? I'm sorry, before I go forward, is everyone else hearing that echo? Okay. So I'll keep going then. Nita, maybe that's something with your speaker. I don't know. I'm sorry, but I'm glad to hear that no one else is hearing that. And I also want to say that in an ideal world, effective brand protection actually starts in the brand creation process. So I have so many clients who come to me long after they have launched and they've been making sales, they've been building clients or customers, they have a lot of brand recognition, maybe a good social media following, but they did not take care of brand protection and trademarks, and they come to me after the fact, and that's extremely common. So if that is you, there's no shame in that. But my ideal scenario is when somebody involves me when they are in the branding process, because it's really vital to get an experienced trademark lawyer to research and determine whether the mark that you want to use and the logo and anything else that you're going to use as a brand identifier, you want to make sure that it is actually available to you, and that by you using it, you're not going to be infringing on somebody else's trademark, which happens a lot more than you may realize. And usually it's inadvertent. But it's a problem because if you're infringing and you don't know it, and you've spent all this time developing your brand reputation and the goodwill that connects with your trademarks, And then you determine later, you're told later, maybe you receive a cease and desist letter, for example, from a brand that says you're infringing. You could end up in very expensive litigation that could result in you actually having to rebrand. And that is a lot more expensive and disruptive than involving a good trademark lawyer from the start. So, and ignorance is not the best policy here. So if you have not taken care of these things for your business, I hope that you will take this to heart. And if you don't reach out to me, reach out to someone that you trust who's an experienced trademark lawyer to help you get this stuff squared away. But I wanted to show you guys some logos. Now, if you guys have attended my other webinars, you've already seen these, but I'm assuming that you recognize these logos. And I think what's so amazing is the power of really strong branding is that you can show someone your logo with no words attached, and everybody will immediately recognize what brands they are. And then also, everybody is probably going to have an emotional reaction. there is an association with each of these brands, and it may be negative, maybe positive, depends on your view of the world. But I could guess that every single one of these brands here, you've got some type of emotional reaction to. You might be a big fan. You might have a negative experience with them, but Apple, Firefox, obviously Mickey Mouse or Disney, Rolling Stone, one of my favorite bands, the Olympic rings, Target, obviously, or Target. And then interestingly, the Tiffany's box, that's not a logo, but it's obviously one of their brand identifiers is that package, as well as that color blue. And the Christian Louboutin shoes with the red soles themselves are also a trademark. And so these are all very, very strong, very well-known brand identifiers. And that's really what your aim is when you are branding. Even if you're starting small, you want to have such a distinctive brand, both in the name and your logo, that and your packaging, your branding in general, that you're instantly recognizable to the people who know you. You don't want to be accidentally confused with a competitor. That's like the worst thing you could possibly have happen. So, okay, so I do have some good questions. So I'm just going to scroll back for a second. And Chantel asks, how early in the process would you prefer to be included? For example, as early as new startup and ideation. I have a little box over part of the word there. I think you're saying something design, build, idea, or pre-seed, seed, or just when branding is starting. I think that it's important when the branding process is starting at the very least. If you're going to be referring to your brand name and you're going to start building a reputation with investors, say you're looking for seed money, the sooner the better, right? Because you don't want to have to change your name midstream. So understand that whatever you choose is what people are going to begin to associate with your brand. So the sooner you can get someone involved, the better. And then Ella asks, how can we determine if branding assets are sufficiently different? Okay, we're going to talk about that. So that's a great question, Ella. You're asking if there's a search or an AI solution that can quickly verify. The short answer is no. And I think as we go forward, you're going to understand why that is. Then Manju asks, for startups with low funding, how should founders best position themselves? What is the budget to keep aside for trademark discovery, attorney, et cetera? And I think this really varies on what type of intellectual property you need. But for trademarks, if you start early, there are a lot of lawyers that work with flat fees, so it's very predictable. I think you need to probably budget a few $1,000s, maybe 5 or 6 for some of the initial legal work you need, if possible. I think you can get a trademark done for under $2,000. It's money well spent. It's an absolute investment in your brand, and it's a lot cheaper than having to rebrand later and dealing with with a potential dispute. So I think that's a great question. It really depends, though. And so that is something that you would need to talk to a specific lawyer about your specific situation, because there are things that will make that vary. Tonya asked, does an author or speaker using their name as a brand need to trademark their name? We're going to talk about that. Excuse me. That's a great question, and we will deal with that. Excuse me. I swallowed the wrong way. Okay. I'm going to take a sip of water. Hang on one second. So I'm not coughing my way through this. So what can you trademark? We talked a little bit about that, but I wanted to show you some other examples of what you can trademark. So obviously you can trademark logos like the golden arches or the Instagram icon. You can trademark taglines like "Just Do It." You can trademark packaging. So we saw the Tiffany box earlier. The Toblerone package down here is a trademark package. The Coca-Cola glass bottle, that design of that bottle is trademarked. It is a brand. I mean, that's a very recognizable bottle shape. Obviously, we would not need to see the Coca-Cola logo on it to recognize that that is a bottle of Coca-Cola. Colors can be trademarked. So Mattel Barbie Pink, which is very timely, they have trademarked that particular Pantone color, as has Tiffany's, their Tiffany Blue. Sounds. So let's see if I can get this to play for you. So that is a trademark sound. Clear brand identifier for Intel, obviously. Motion can be trademarked. So this is a Lamborghini, and these are called Lambo doors. And that is actually trademarked. It's not, I mean, I'm sure they have a patent in it as well. But as I mentioned earlier, patents don't last as long as trademarks. The trademark can be indefinite as long as you continue to use the mark and you renew it in the prescribed renewal periods. Whereas a patent would expire after 20 years, or maybe even 14 if it's a design patent. And we'll talk about that in a minute. So I just think it's really kind of fun that they trademarked that because that means no one else can have those doors, probably both from a patent perspective, but also trademark. And then smell. So Play-Doh, the smell of their Play-Doh, of the dough, it is trademarked. So honestly, anything that would be a brand identifier could be trademarked. So like we talked about the Christian Louboutin shoes, the sole of the shoe, which I think falls under packaging potentially. But really as creative as you can be.
Yeah, I need to go pick her up.
And whoever, if everybody could mute themselves. I don't how do I mute everyone? Let's see. Maybe she figured that out. So make sure, if everybody would, that you have muted yourself so that we don't have anybody talking over the recording. Okay, so those are just some examples. Yeah, Meju, thanks. If everybody could just mute themselves, that would be great, because I'm in my presentation right now. So okay. And I mentioned that I have people coming to me after the fact, and they often say, I wish I had known that I needed to do this. I wish I had known what it took to have a strong mark. It is something that I have clients regret routinely because they are involved in litigation and potentially having to rebrand, and they're spending tens of thousands of dollars on defending themselves. And even if they don't defend themselves, even if they capitulate and agree to rebrand immediately, there's going to be the cost of rebranding and just the time and energy that you're going to have to spend re-educating your target audience and your client and customer base. So obviously, because of that, this is why this applies to you, because what you don't know can hurt you. Ignorance is definitely not bliss in this situation. And I like to use this graphic for those of you who remember the Jetsons. George Jetson was on a treadmill there and he couldn't get off of it. It's sort of an iconic moment for cartoons when I was a girl. But that is really a good illustration of what litigation is, because it's relatively easy in the US to launch litigation. It's very hard to get out of it once it's launched without spending some money. So the goal is to pick a brand that is not going to put you in at risk of litigation. Ella, oh, sorry, no, I was not. You were saying if trademark renewals are every 10 years, why would one budget for $6,000 a year? I meant in total, and I meant for other things too, like copyrights and contracts, not patents, because patents are expensive. That would be just a one-time shot right in the beginning. And renewals are actually more frequent than every 10 years in the beginning. So we'll go over that in a minute, just to make sure everybody understands when renewals are due. So let me just go over really quickly sort of what the rule of thumb is for a strong brand. The most important thing is that you do not want to choose a brand that describes what you do. Descriptive marks are not trademarkable. You need a mark that is defined as fanciful and unique. That's the language in the trademark statute in the US. You don't want to use words that are commonly used in your industry. You don't want to use buzzwords or phrases, because inevitably others in your industry will be using those and they will be inadvertently infringing on you, which is why the USPTO will not register marks that have those things in them generally. And then geographic references can also be considered descriptive. So I would avoid those, like don't put, your state name or your city name or something that is a landmark in your area. All those things are going to be problematic. And will make it hard to get registration. I created a fake logo here, this online video rental company, just to give you a really, really clear example of a descriptive mark. And that, that's what you want to avoid. Netflix is a great example of a mark that it actually does sort of describe what they do, but it's a made up word. And so that's what makes it fanciful, unique, and memorable. That's what makes it a really strong brand. And so if you can be super creative like Netflix and come up with something like that, that would absolutely work. But you don't want something like this that is very generic, very descriptive, not memorable, and is going to sound like every other your business in your industry. That's the last thing that you want. And the benefit of this is that if you pick a name that is fanciful, unique, memorable, the URL is going to be available to you when you're launching, and your trademark has a super strong chance of approval. So those are also great reasons to pick something really unique and memorable. So let's talk about strong marks beyond that, beyond something that isn't descriptive. Ideally, like the most ideal option for choosing a strong brand is to make up a word or phrase. IKEA is a great example. I and K are the first letters of the first the first letters of the first and last word of the founder of IKEA, and the E and the A are the first letters of the towns that the founder has lived in. So totally made up, very unique, obviously very, very strong brand. Another example is Haagen-Dazs. Haagen-Dazs looks like it's an actual word it looks like a Danish word, but it's not. It's actually not a real word. It's made up. And I think it's very creative because it gives a very strong sense of what the brand is about, right? This, European ice cream, very luxurious, rich ice cream made with, very pure ingredients. It's a fabulous brand. And because it's made up, very easy to get a trademark in it and the URL. Now, one word of caution with using words in other languages, the USPTO will translate words in other languages into English to see if there's the English equivalent of that word already being used as a trademark in the US or already registered. And if it is, then you're going to get refusal. So choosing the foreign translation of a word that you want to use is not necessarily a good way to go. But if you do what Haagen-Dazs did and make up a word that looks like it's in another language, that can be very, very effective. Now, Anne Ju asks, would Netflix have trademarked the sound as well as the logo? I don't know if they have trademarked a sound. I think they would have if it's a brand identifier. I'm trying to think of what Netflix's sound is. Is that the sound when you turn it on? I think I know what you're talking about. They probably do have that trademark. That's a great question. I'll have to look that up. And yes, they definitely would have trademarked the logo. You generally want to trademark both the word with no design attached or the phrase and the logo. Like Starbucks, for example, Starbucks has a trademark in the name Starbucks with no design attached to it. So they can use that word however they want in their industry. And they've got multiple classes of goods and services that trademark covers, not just coffee. And their logo obviously is trademarked as well. And so those are vital because those are really, really important assets, and you have to be able to own those exclusively and prevent people from copying those. So that is a given. You must have a trademark in both the word with no design attached, the word mark. We also call it a standard character mark, and the logo or a design-based mark. Okay, so option 2 If you can't come up with something totally made up, then you could use a word or a phrase that's not related to your business. So Amazon, Starbucks, Banana Republic, Apple, these are all really good examples. And potentially you're still going to be able to get the URL. The trademark's probably available to you if nobody's using anything similar to this in your industry. It's possible that by choosing a word or phrase not related to your business, it might communicate your message in a subtle way. Banana Republic, I think when they first launched, their clothing was very Indiana Jones kind of safari style. And that, but the phrase Banana Republic, I think, sort of gives you this image of a tropical, maybe, third world country, that sort of style. So I think they were at the time communicating their sort of what their style was without describing exactly what it is they sell. If you can't come up with that, the third option would be to use a word or phrase that is suggestive, so sort of descriptive. It suggests what you do, but is still unique. Some great examples are Nike. Nike is is it the god or goddess of victory, which is perfect for a running shoe company, which is now a huge sporting company, obviously. Wrangler is a great name. Wrangler describes their ideal buyer. So I think that's a very creative mark. And the logo is obviously very creative too, because it looks like a brand. Timex is a made-up word, but clearly that company's got to have something to do with time or timekeeping. And Stitch Fix, I think, is a great example. I love that brand. It definitely does give you a sense of what they do. And the word stitch is not a made-up word. The word fix is not a made-up word, but the combination of them two together is a new thing. I think it's such a clever way to describe a company where you're getting your fix of new clothes every month or every quarter. So that's a great brand. So those are some examples of what a suggestive mark would look like. Now, so this goes back to the question I got earlier. Can you use your given name as a trademark? You can, and this can be especially good if you're a designer or a thought leader, like an author or speaker, something like that. Oprah Winfrey is another person that has a trademark in her name. It's just in Oprah. And so that can be very effective. Just one caveat: last names are hard to trademark because they are generally considered merely a surname, which is a form of a descriptive mark. The USPTO does not want to prevent other people from using their own last names in their business. So generally, if you try to trademark just your last name, you're probably going to get a refusal. But you can trademark your entire name. You can certainly use your entire name, but it may take a few years for your mark to gain distinctiveness apart from you as an individual. And that's really what we're looking for with trademarks. They have to be an indicator of the source of goods, not referencing an individual person. And so it may take a little bit longer to get registration, but it's definitely something you can do. And obviously there are brands like Rebecca Minkoff, Diane von Furstenberg, Harry Winston, Louis Vuitton. These are all real people that have trademarks in their names. Now, depending on how unique your name is, it may not stand out. So it may not be a very strong brand, but it could be a very, it could be exactly what you want to use. And if your name's unique, the URL will probably be available too. So finally, option 5 would be to use a fictional proper name. So you actually make a name up. Tommy Bahama is, the best one I can think of. J. Crew is also a fictional name, as is Betty Crocker. Tommy Bahama I love because as I understand it, the company uses that as their avatar as well for their ideal buying customer. And so I think there are a lot of questions that go into team meetings, like what would Tommy want? What would Tommy buy? What would Tommy do? And so I think that's a really creative way to come up with a brand that also helps inform your strategic decisions for your business. And I think a fictional name that's clearly not somebody's name, like Tommy Bahama is clearly not someone's name, would be easier to get than a real name. So those are the ideas I can give you on how to come up with a strong mark. Once you have come up with it, well, and let me just go back before we talk about use. I got the question about trademark research and knowing whether the name is available to you. And I think a lot of people think that if you search the USPTO website and you do a Google search, that if you don't find that mark, you're good to go. But that's unfortunately not the way it works. As a trademark lawyer, I have access to to paid databases that are, sorry, I had to turn off my fan. I think it's drawing my throat out. Paid databases that are actually quite expensive. Lay people would not pay for access to them because they're expensive. And so when I do a trademark search, it's quite detailed. And not only am I just scanning it to look for identical matches, but I'm looking for marks that are similar. And then I have to use my years of experience and knowledge of trademark law to determine, are those marks similar enough that it would pose a problem for my client with the mark that they want? And often that involves going in and researching the history of those marks, how the USPTO treated those marks. There's quite a lot of work that goes into the research. And to date, there's no AI program yet that that can do that type of analysis. It can do searches, and a lot of the search platforms do have some sort of AI in them and have for a while. I do think the AI is going to improve over time, but nothing will ever take the place of an experienced trademark lawyer being able to advise you about the risks, because so many times the decisions that you're making are in the gray area. It's not black and white, and you have to make a cost benefit decision about, am I willing to take the risk and go ahead and choose this mark and file for a trademark application, knowing that we may face some issues down the road. So it's not something that you can really do on your own and have a clear idea of what you're facing without having that advice. So Ella said that she used Trademarkia to check, and it worked when adding yeah, Trademarkia. Those services are very, I feel like they do a real disservice, because it gives you this false sense of security that, you know, that if they did the search and then they don't see a conflict, you're good. But AI is just not good enough yet to be able to warn you of the gray area risks and the marks that are out there that you might face disputes with someone who may perceive you as likely, you know, confusing with their mark. And so to me, I have a real problem with those services, because I feel that they give you a real false sense of security. And I have a lot of people that hire me after the fact when they use those types of services and they try to file for their own trademark, and then they end up in trouble and I have to come in and try to fix it for them. So be very careful in relying on those search platforms, because they are definitely not able to give you legal advice. It's actually illegal for them to do it. They're not a law firm. A lot of like LegalZoom, being one of the first companies you know, to do this type of stuff, got sued by a huge number of the different states' attorneys generals for the unauthorized practice of law years ago. So they have to be very, very careful about not giving you legal advice. And if you read the terms and conditions on those websites, it's obvious that they're not trying to give you advice. So you have to be really careful about relying on the information you get from those types of websites. So we've got some other questions, and I'll get back to them if I can, because I don't want to run out of time, because we've still got some other types of IP to work through. But really quickly, I want to talk through how you protect your trademark. So if you get the green light from your lawyer that the mark appears to be available, then you want to start using the mark. And use is defined as offering the goods or services for sale across state lines generally. If you have a website, that counts. If you're on, you know, if people are traveling on interstate highways and they may do business with you, even if you have a brick and mortar location, a restaurant or a store, you still could technically be in interstate commerce and qualify for a federal trademark. But you have to start using the mark, because that date when you first start using the mark on your goods or services as a source identifier is going to determine who has priority rights in the mark. So that date of first use is really important. So you want to start using it as soon as you possibly can. And I want, you know, make sure you keep, you know, records of that use. Take a screenshot of your website is always a great example, so that you can prove it if you need to, if you ever end up in a dispute. And also use is great because it starts to build your goodwill and your brand exposure and your brand reputation. These are all really important things. So use is vital for that as well. But if you're not using the mark yet and you're in development, for example, maybe you're raising money, you haven't actually sold your product or your service yet, then you still can file under what's called an intent to use option. And I highly recommend this because basically, if you qualify, if this gets approved by the USPTO, you end up with what's basically a name or a brand reservation. And so people cannot come in behind you and use something confusingly similar. So it gives you time to finish the launch or development of your product or service without having to worry about that. So I highly recommend using the intent to use option. A good trademark lawyer will know how to do that. And I just wanted to show you really quickly what acceptable proof of use is. So this is something you're going to have to provide to the USPTO. The mark must be on the product or the website where the services are offered. It can be in other things like your advertising. It could be on your invoices or your scope of work, to prove that you're, offering services with that branding. And you have to use it in the exact way it's being provided to the USPTO. Now, this really matters as far as the wording. So you want to use the exact phrasing in your marketing and on your website and on your product or service that you do in the application with USPTO. And with your logo, it has to be the exact design that you submit. Now, I'm not talking color, because generally you don't want to claim color as a part of your application with USPTO, but the layout, the font, the design elements need to be exact. And when you begin using the mark, you then want to start using it you want to then use it continuously from that date of first use going forward, because that's what's going to qualify you for continued trademark protection. These are just some examples really quickly of acceptable proof of use specimens. If you've got something like clothing, that label in the back collar is acceptable. On the watch, you see the name Rebecca Minkoff on there. That's acceptable. It could be on the packaging. It could be on a tag, a hang tag. And as I mentioned, on your website. So Macy's has their logo up here in the corner. That's going to be sufficient for online retail services. Same with Sephora. Now, Sephora also sells Sephora branded goods. So if they want a trademark for the goods themselves, they have to show a picture of the actual good with the mark on it. So the website itself would not necessarily be a good specimen for the goods. It could be. It depends on what is shown in that screenshot. Okay, and finally, once you get registration, that's only half the battle. You want to monitor the mark. So you have to actually monitor the marketplace for infringers. And if you fail to do this, if you fail to monitor and police the marketplace for infringers, you risk potentially losing your rights. So if you catch an infringer, you have to send, now I would do this through a lawyer, but you have to send a cease and desist letter. You have to, if they don't cease and desist, you have to keep going. You have to go to court, get an injunction, consider money damages, because if you don't defend your mark, it's possible that you could be deemed to have acquiesced to another brand's use of your mark or even waived your rights, and somebody could potentially petition to cancel your trademark. So this is really, really important that you stay on top of this. I would never try to do this alone. I would always have a good trademark lawyer assisting you with this to know when to send a cease and desist, how to word things. But this is a really important part of maintaining your rights, and it's something you have to do going forward. And this is the benefit of having a registered trademark, is that you have these remedies available to you. You don't have these remedies, the ability to get an injunction, the ability to have them disgorge profits gained from their infringement, potentially even getting your attorney's fees covered. These types of things only come with having a federally registered trademark. So some frequently asked questions I get is, if I own the URL, or if the URL is available and I buy it, do I own the mark? No, the URL has nothing to do with your trademark. And in fact, if someone else owns the trademark and you buy the URL, they can actually force you to hand the URL over to them, potentially. So the URL does not grant any rights with respect to your trademark. But if the .com version of the URL is available, that's a good sign. If it's not, if it's like the .net version, .co version, or the hyphenated version, I would be concerned, and I would want to go look and see who's using the .com version and make sure they're not a competitor. And if they are, I would forget that name and move on to another brand. If you use that TM symbol on your mark, are you protected? You are somewhat protected. It is putting the world on notice that you're claiming a trademark. And so that does at least tell people you're claiming it. It might disincentivize people from copying you, but it doesn't really confer all the rights that you're going to get when you get a registered mark. That R with a circle around it is the mark that you can use once you have registration. Don't use it before then, because it's actually illegal to use that until you have registration. But the TM will at least put people on notice that you're claiming a trademark. So I would definitely use it. And I've already talked about why you need a federally registered trademark. So that is really important information. So make sure that the name you want is not already registered or being used by someone else. Make sure it's not generic slang or industry buzzwords. Make sure it's not descriptive, and make sure that it's not geographically referring to where your business is located. And finally, with respect to marks, this is a problem I would love for all of you to have your mark become so popular, so well known, that it becomes at risk of being genericized. And that's where your mark turns into a noun or a verb. That's not a good thing. You could lose your rights if you allow that to happen. So if you are at risk of that, make sure you employ a really good trademark lawyer to help you go on a campaign to educate people and try to prevent that from happening. There's other marks like Velcro. Velcro had a really funny ad campaign a few years ago, trying to educate people about how Velcro is a brand name, not the product itself. And these three marks right now have all faced the same problem. Google is actively facing that issue right now, obviously, which makes sense. So, and lastly, just don't infringe on other people's marks. Do your due diligence. I would have a good lawyer help you make sure you're not infringing on existing marks. Don't copy other people's branding, color schemes, or packaging. Make sure that your brand is strong and unique, like we've talked about. And I would recommend getting an IP audit done by an experienced IP lawyer who can look at your business as a whole and identify areas of risk. We're going to talk about that in a minute. And really quickly, how would you monetize trademarks? Well, obviously, you could put them on your goods and services and sell them. You could put the mark on merchandise and sell that directly to the public. So like t-shirts, baseball caps, bags, whatever. You can use your brand and branding to create a loyal following and goodwill so that you get repeat business. And you can license your marks to others to use on their goods, and you can get royalty payments for those. And then ultimately, you can sell your trademarks. You can sell them along with your business or even as standalone assets. And these are just some examples of just showing the power of licensing. These numbers are the royalty revenues that these companies have gained just in the last year. I don't actually know the time period this is covered by, but it gives you a sense of how powerful and lucrative licensing deals can be. So, and here's a few visual examples for you. Collaborations have become a really big thing. So we have Gucci and Nike doing a collaboration. We have Mattel and Maserati doing one. Disney is obviously, Disney has collaborations with a lot of brands. These are all licensing. This is a licensing deal for sure. Fanatics has licensing deals with all, most of the major sports franchises. And then a new one that I came across was Disney, and specifically Star Wars, with Thomas Kincaid, the artist. They actually have a whole art line and product line. So there's lots and lots of ways to monetize your trademarks once you begin to build a strong reputation. So let's see, Tonya, Discover Card is an interesting brand issue given the verb issue. Oh, interesting. Yeah, I could see how that could potentially be an issue. But so let's quickly jump into copyrights. Luckily I don't have quite as much detail for the other remaining types of intellectual property, although they are very important as well. But copyrights, as I talked about, protect original works of authorship in tangible form. In the US, copyright protection is automatic. So as soon as you create whatever it is, if you write the book, you record the podcast, you record the video, you finish the painting, you take the photograph, you finish writing the sheet music, you perform the music. Those are all tangible forms of authorship, and the protection of the Copyright Act is automatic. But copyright registration will give you broader protection and legal remedies similar to what a trademark gives you. So my recommendation is that you that you copyright, you register with the Copyright Office anything that you don't want copied. So if it's something important to your business, if it's something that you sell in particular, if you sell products that you want copyrighted, you don't want copied, getting copyright registration is vital to protecting your rights. And a registered copyright can be monetized through sales or licensing, similar to a trademark. So really quickly, this is what U.S. copyright law provides copyright owners if you have a registered copyright. So you're going to have exclusive rights to reproduce the work in copies. And these are words taken from the statute. Phonorecords is the language in there. Obviously, the statute was written a long time ago. Prepare derivative works based on the original work. Distribute copies of the work to the public by sale, by transfer of ownership, by rental, lease, or lending. And obviously, that would include licensing. It gives you the right to perform the work publicly if it's a literary, musical, dramatic, or choreographic work. It also covers pantomimes and motion pictures or audiovisual works. It gives you the exclusive right to display the work publicly if it's literary, musical, dramatic, choreographic, pantomime, pictorial, graphic, sculptural, and it includes motion pictures or audiovisual work. And it also includes digital audio transmissions, sound recordings, so like podcasts, for example. And it gives you the right to authorize others to exercise any of these rights as well. And again, that would be through licensing. So copyrights are very powerful. I just thought I'd show you some really cute examples or fun examples of copyright, of ways copyrights are used and monetized. These are movie posters. So obviously the movies themselves are copyrighted. So is the artwork in the posters. These are books. So the book covers and the interiors, the content can be copyrighted. Now, book titles cannot be trademarked. So you can't keep someone else from using a similar or even identical name on another book, but you can protect the content of the book itself and the cover design. This is music. So we've got the soundtrack from the Barbie movie. We've got sheet music from Star Wars. An interesting issue, if you guys are paying attention to what's been going on with Taylor Swift, she had a really serious copyright issue with her original master recordings of her, I don't know, first like 5 albums, something like that. Speak Now is one of them. And she lost her copyrights. So she has gone on a campaign to begin re-recording all of her original music so that she can own new masters and new versions of those songs. So that is another thing you can do. This is coding. So the coding behind an app or a website, for example, is something you can copyright. If you're a speaker, your speech, the written speech can be copyrighted. The performance of the speech can be copyrighted. The video and audio recording of the speech can be copied. Those are all separate copyrights. And then if you have programs like coaching programs, for example, the content within those programs is copyrightable. So that would include the handouts. It would include the recordings, either video or audio. And then the website itself, the copy on the website, the layout, the design, assuming that it's not built on a templated platform, you can own the copyright in it. And then obviously this is Mickey Mouse. So this is Steamboat Willie, the original Mickey Mouse. He is entering the public domain. The copyright on this story, the Steamboat Willie story, expires next year. So copyrights last for the life of the creator plus 70 years now. Now, when this was created, it was a 95-year period. It's changed since then. So for your purposes, it would be the life of the author or the life of the creator plus 70 years after that is how long copyright lasts before it enters the public domain. And then finally, this is another partnership between MAC Cosmetics and Keith Haring, the artist. They created a series of NFTs, which are also copyrightable objects, and sold them. So they went into a licensing partnership with each other. And so I think that's super interesting. So talking about how to monetize copyrights, some of what we just talked about is monetizing, but here are some other examples. Obviously, you can sell sheet music. You can sell goods with the licensed brand and copyrighted object, like the ears there are copyrighted and trademarked. Mickey Mouse is covered in both realms. So are all the Star Wars characters and the stories. These are video games. That's another way, video games are obviously copyrightable. They have many, many components to them that are copyrightable. And then Google is obviously, they have coding, they have an algorithm, which is copyrighted, and they monetize that by giving people access to it so they can use that to benefit through ads. Same with Meta. And then we've got Barbie's digital version of the movie. The streaming version is coming out. So they've been doing pre-sales for that. And then theme parks, that's another great way to monetize copyrights, obviously. Lots and lots of copyrighted components are incorporated into theme parks. So these are just some examples of how you can monetize your copyrights. Step 3, patents, how to protect your inventions and designs. As I mentioned, patents protect new inventions or innovative methods. The subject matter must be patentable, and that's defined by statute. It's also interpreted by the courts. Again, you need a good patent lawyer to help you with this. Your idea must be new, useful, and non-obvious. And again, you want a good lawyer to help you interpret that and determine whether what you created is those things. This is one big landmine for people who are creating new designs or tech or innovative methods. You can disqualify yourself from being patented if you sell or offer to be sold that item, if you use it, or if you display it in public. Any of those things can disqualify you. Also, if a previous patent application was filed for the same invention. So you have to be super careful who you show these designs to. And again, that's why if you have something that you think might be patentable, get a patent lawyer involved as soon as possible so that you don't accidentally lose your rights. And again, you may need patents in more than one country, so you need to plan ahead for that, because there's just like here, where you can be disqualified from getting a patent after you engage in certain activities, it's the same in other countries. You need to make sure you understand the laws in those countries, so you don't disqualify yourself. And you have to apply very quickly for the patents in all of those different countries. That's not something you can wait on. And again, patents don't provide long-term protection. They are much more limited than copyrights and trademarks, so you're generally going to want both. There are really two types of patents that most people are going to be looking at. Utility patents are for anyone who invents or discovers a new or useful process, machine, article of manufacture, composition of matter. So this would include pharmaceuticals, for example, or vaccines, which is a timely subject, or any new or useful improvement of those things. And those are good for 20 years. Design patents would be granted for someone who invents a new, original, or ornamental design. And that's the key. It has to be ornamental. It cannot be utilitarian. And those are good for 14 years. Interestingly, you can also get a patent if you invent asexually reproduced plants, like new variety of plants. And those are good for 20 years. So I think that's super interesting as well. But again, talking to a good patent lawyer is vital to make sure that you protect yourself. So we're in the home stretch now. We're going to talk about trade secrets really quickly. This is protecting your confidential and proprietary information. And in order for something to be a trade secret, it must be commercially valuable because it's secret. Mentioned earlier, like Coke's recipe. It has to be known only to a limited group of persons. It has to have value to others who could not legitimately obtain that information, like competitors. So if your competitors would really want to get their hands on it, that makes it valuable. it has to be subject to reasonable security efforts to protect its secrecy. So you have to be very careful about how you protect the secrecy. If you're not careful about that, you're not going to have trade secret protection. And examples of trade secrets would include chemical formulas, recipes, product designs, consumer and contact lists, pricing schedules, manufacturing techniques, marketing strategies, etc. I think I mentioned earlier pricing. Oh yeah, pricing schedules is on here. So these are all really, really important things. And honestly, they are kind of what makes your business unique. It's what it makes your business what it is. So trade secret law is so important because it protects much of the information that makes a business truly unique. And a failure to identify and protect it can result in lost competitive advantage, loss of your core business technologies, and reduced, if not completely eliminating your profitability. So this is not an afterthought. It's something you have to give a lot of thought to and be very careful in making sure you're protecting your trade secrets. Here are some examples of how you can do that. You need to mark the information as confidential. You've probably seen documents with the watermark confidential across the document. You can also put it in the header. It needs to be very noticeable, that word confidential. You need to limit access to the information by placing physical and technological restrictions on it. You need to enter into non-disclosure agreements with employees. Now, someone asked me about NDAs earlier. This is where we're going to talk about this. You want to enter into these non-disclosure agreements, and you want employees to sign them, suppliers and partners, vendors, independent contractors of all kinds. You need to prohibit the recipient from making unauthorized use of or disclosure of that confidential information. Again, you want a good lawyer to draft this for you. You do not want to try to do this yourself. Do not use somebody else's NDA. Don't try to buy a template offline and think it's going to cover you adequately. And you also need to review periodically which employees need to know the trade secret information. So the only people that get access to it should be the ones that are on a need to know basis. And then really work on creating an employee culture that makes maintaining confidentiality a priority. You need to train your employees to understand the importance of confidentiality. So that's it. That's a lot. But the last thing I wanted to talk about, and this is sort of a bonus step, is how to protect your IP holistically. And as I mentioned before, you can layer different types of IP for full protection. So a patent might protect the technical feature of a product. A trade secret would protect the specific settings that improve that product's performance. A copyright would then protect the source code, texts, and drawings, maybe that would be in the user manual, for example. And trademarks would protect the branding associated with that product and that company. So as you can see, there's multiple layers that you need to be looking at to make sure that you have full protection, and the longest term protection that you can possibly get, with obviously trademarks and trade secrets being the things you can own indefinitely. So my advice is that you make sure all of your agreements specifically protect your trademarks, copyrights, patents, trade secrets, and other IP, and identify who owns the IP and everything, particularly if you're engaging in a joint venture with someone or a collaboration with someone. If you work with independent contractors or vendors to create intellectual property for your business, you need to use what are called work for hire provisions. And that is because in the US, under the Copyright Act, if an independent contractor creates something for your business that is intellectual property, they own the IP in it. You don't, which it sounds crazy and backwards, but that is the way it is, because they're the ones that actually created the IP. And so you have to get them to sign a work for hire provision, ideally when you're hiring them, not after the fact, that automatically assigns the legal rights in whatever it is they're creating for you to you or to your business, so that you own your IP. Now, if you have IP, and this can include logo design, website design, branding, your products themselves, like there's a lot of things that you could have had an independent contractor or outside vendor or service provider create for you. And if you didn't get work for hire provisions, then technically you do not own the IP. And that's problematic for two reasons. One, because you want to control it. for lots and lots of reasons, but also, and you want to prevent them from being able to come after you and suing you for a share in your profits later. But also, you cannot get copyrights and trademarks in things you don't own. And so you have to make sure you own the IP before you can secure registrations to protect them. And so again, you need to have a good lawyer help you secure these after the fact. If you didn't do it, there are ways to do it. And I would definitely hire a lawyer. This is something I help my clients with all the time. And most of my clients didn't get work for hire provisions when they should have. So this is a really common issue. Be careful that you don't inadvertently license your IP to others without meaning to. And where you do intend to license it, avoid exclusive, irrevocable grants to your company of your company's rights to other people. Again, this is why you need a good lawyer drafting these contracts for you. Make sure you secure registration in your trademarks, your copyrights, and patents in any country you're selling your goods or services, if possible, if it's possible to do. Register your trademark and other IP with U.S. Customs Border Control to prevent infringing goods from entering U.S. commerce. So say you didn't get, maybe you manufacture in China, you didn't get IP protection in China, your factory starts knocking off your goods and putting, your brand on them, maybe they're counterfeit. U.S. Customs Border Control can prevent those counterfeit items from entering U.S. commerce. So that's a really important part of protecting yourself. And then have the strongest non-disclosure, confidentiality, and non-compete agreements you can have with employees and contractors and vendors. Now, non-competes are not enforceable in every state, and non-disclosures can be greatly limited. So it really depends on your state. So this is where I would talk to a really good lawyer in your jurisdiction about how to protect you. So I know this has just been a ton of content. I'm so happy that you guys joined me. I'm sharing some information on how to find me. If you want to schedule a free consult, you can do that. I would really love it if you would connect with me on LinkedIn. My LinkedIn link is down there on the bottom next to the QR code. Feel free to take a picture of this slide. And I hope it was helpful. I'm sorry I wasn't able to get to all of your questions, but feel free to put them in the group. We can still interact with each other in Chief where I scheduled this. So feel free to go in there and ask further questions, and I'd be happy to answer them for you. So I'm sorry we went a little long today, but I'm super happy that you guys joined me, and I'll see you guys on the next one. You guys have a great rest of your day and week.